If you are a green card holder living in the United States right now, what I'm about to tell you could change everything. In 2026, the Department of Homeland Security has confirmed expanded enforcement protocols that are putting certain permanent residents at serious risk of deportation. And I'm not talking about undocumented immigrants. I'm talking about people who have legal permanent residency, people who have been here for years, people who thought they were safe. This is not fear-mongering. This is not clickbait. These are documented policy changes that immigration attorneys across the country are already preparing their clients for. By the end of this video, you will understand exactly who is at risk, what has changed, and most importantly, what you need to do right now to protect yourself and your family. Stay with me because this affects millions of people, and the information I'm sharing today could be the difference between staying in America and being forced to leave. Let's start with the facts. The United States Citizenship and Immigration Services, along with Immigration and Customs Enforcement, have rolled out what they're calling enhanced vetting and enforcement measures for 2026. These measures were quietly announced in late 2025 and officially took effect in January 2026. So what exactly changed? First, there has been a significant expansion in criminal inadmissibility reviews. What does that mean in plain English? It means that USCIS and ICE are now conducting deeper background checks on green card holders, especially those applying for citizenship, re-entry permits, or any immigration benefit. Cases that might have been overlooked 5 or 10 years ago are now being flagged and reviewed. Second, there is increased scrutiny on immigration fraud. The government has invested millions of dollars into fraud detection algorithms and investigation units, specifically targeting marriage fraud, employment-based fraud, and misrepresentation in past applications. Even small inconsistencies in your original green card application can now trigger a full investigation. Third, ICE enforcement priorities have been updated. While the focus has always been on serious criminals, the definition of what counts as a deportation priority has broadened. This includes individuals with certain misdemeanor convictions, those who have violated the terms of their residency, and people who have spent extended time outside the United States without proper authorization. Fourth, extended background reviews are now mandatory for green card renewals and naturalization applications. This means your entire immigration history, your travel records, your criminal background, even your social media presence in some cases can be reviewed in detail. And finally, there are stricter consequences for abandonment of residency. If you've been outside the U.S. for more than 6 months without a re-entry permit, you could now face questioning, detention, or even removal proceedings when you try to return. These are not minor tweaks. These are structural changes to how the U.S. government monitors and enforces immigration law for people who already have green cards. Now let's talk about who is actually in danger here. Not every green card holder is at risk, but certain categories of people need to pay very close attention. First, green card holders with any criminal record. And when I say any, I mean any. Even if you were arrested 20 years ago for something minor like shoplifting, disorderly conduct, or driving under the influence, that record is now being reviewed. Crimes involving moral turpitude, domestic violence, drug offenses, theft, fraud, or any aggravated felony are particularly dangerous. If you were convicted of a crime and you completed your sentence but never had your record expunged or sealed, you could be flagged. Second, people who have spent long periods outside the United States. If you are a green card holder and you have been living abroad for work, family reasons, or personal matters, you may have unknowingly abandoned your residency. The law says that if you stay outside the U.S. for more than 1 year without a re-entry permit, or if you take multiple trips that last 6 months or more, immigration officers can argue that you intended to abandon your permanent residency, and once that argument is made, you can be placed in removal proceedings. Third, Conditional green card holders. If you received your green card through marriage and it's still conditional, meaning it's only valid for 2 years, you are under extra scrutiny. If your marriage ends before the conditions are removed, or if USCIS suspects the marriage was fraudulent, you could lose your status and face deportation. Fourth, individuals who provided inaccurate or incomplete information on their original green card application. Maybe you forgot to mention a previous arrest. Maybe you didn't disclose a prior visa overstay. Maybe you misunderstood a question and answered it incorrectly. In 2026, those mistakes are being treated much more seriously. Misrepresentation, even if it was unintentional, can be grounds for deportation. And fifth, people involved in any immigration fraud investigations. This includes fake marriages, fraudulent employment sponsorships, or using false documents. Even if you were not the primary person committing fraud, if you benefited from it in any way, you are at risk. Let me give you some real-world examples so you understand how this works. Scenario 1. Maria has been a green card holder for 8 years. She got married to a U.S. citizen, removed the conditions on her green card, and has been living a normal life. But 10 years ago, before she got her green card, she was arrested for writing a bad check. The case was dismissed, and she never thought about it again. Now in 2026, she applies for U.S. citizenship. During her interview, the officer pulls up her criminal record and asks why she didn't disclose the arrest on her naturalization application. She says she forgot because the case was dismissed. The officer decides to refer her case for further review. Maria is now facing a potential denial of citizenship and possibly removal proceedings for failure to disclose. Scenario 2. Raj is a green card holder who works for a tech company. His job requires him to travel frequently to India. Over the past 2 years, he has taken 3 trips that each lasted about 7 months. He thought he was fine because he always came back. But when he returns to the U.S. after his latest trip, the customs officer at the airport pulls him aside. They question whether he actually intends to live in the United States. They accuse him of abandoning his residency. Raj is detained and given a notice to appear in immigration court. Scenario 3. Ling received her green card through an employment-based petition. Her company sponsored her, and everything seemed legitimate. But in 2026, USCIS starts investigating her employer. They discover that the company was running a fraudulent sponsorship scheme, filing fake job postings and paying employees under the table. Even though Ling had no idea this was happening, her green card is now under review. She could lose her status because the original petition was based on fraud. These are not extreme cases. These are the kinds of situations that immigration attorneys are dealing with every single day right now. Let me clarify something important. When people say deportation, what they usually mean is removal. Deportation is the old legal term. The current term is removal, but they mean the same thing: being forced to leave the United States and return to your country of origin. Here's how the process works. If USCIS or ICE believes you are removable, they will issue you a notice to appear. This is a legal document that tells you to show up in immigration court on a specific date. It will list the reasons why the government believes you should be removed from the United States. Once you receive a notice to appear, you are officially in removal proceedings. This means you are now in the immigration court system, and a judge will decide whether you can stay or must leave. During your court hearing, you have the right to be represented by an attorney. You can present evidence. You can argue your case. You can apply for relief from removal, such as cancellation of removal, asylum, or adjustment of status. But here's the critical part. If you lose your case and the judge orders you removed, you will be deported. You could be barred from returning to the United States for 10 years, 20 years, or even permanently, depending on the circumstances. And even if you have a green card, you do not have the same protections as a U.S. citizen. Citizens cannot be deported. Green card holders can. This is why understanding your rights and your risks is so important. So, what should you do if you're a green card holder in 2026? First, be extremely careful about international travel. If you need to leave the United States for more than 6 months, apply for a re-entry permit before you go. This document proves that you did not intend to abandon your residency. Without it, you could face serious questioning when you return. Second, review your criminal record. If you have any arrests or convictions in your past, even if they were minor or a long time ago, consult with an immigration attorney. Some offenses can be expunged or sealed, which may reduce your deportation risk. Do not assume that because a case was dismissed or you completed probation, it won't matter. It does matter. Third, always keep your address updated with USCIS. This is a legal requirement. If you move and don't update your address within 10 days, you are violating immigration law. That violation alone can be used against you in removal proceedings. Fourth, avoid any behavior that could result in criminal charges. Even a minor arrest for something like disorderly conduct or petty theft can now put your green card at risk. Stay out of trouble. Fifth, if you are eligible for U.S. citizenship, seriously consider applying. Naturalization is the only true protection against deportation. Once you are a U.S. citizen, you cannot be removed from the country except in extremely rare cases involving fraud in your citizenship application itself. And sixth, if you receive any notice from USCIS, ICE, or an immigration court, do not ignore it. Do not try to handle it yourself. Get an immigration attorney immediately. These cases are too important to risk doing it alone. Let me clear up some dangerous myths that are putting people at risk. Myth number 1, once I have a green card, I'm permanently safe. This is false. A green card gives you the right to live and work in the United States, but it does not make you immune to deportation. Green card holders can be removed for criminal activity, fraud, abandonment of residency, or violations of immigration law. Myth number 2, old criminal cases don't matter anymore. Wrong. There is no statute of limitations on deportability. A conviction from 15 years ago can still be used to deport you today. In fact, with the new enforcement measures in 2026, old cases are being reviewed more carefully than ever. Myth number 3, ICE only goes after undocumented immigrants. Not true. ICE has the authority to arrest and deport green card holders who are removable under the law. In recent years, we have seen an increase in the number of lawful permanent residents being detained and placed in removal proceedings. Myth number 4, if I just stay quiet and don't apply for anything, they won't find me. This is a dangerous gamble. USCIS and ICE have access to vast databases. They can cross-reference criminal records, travel history, employment records, and more. If there is a reason to investigate you, they will find you eventually. And when they do, the consequences will be much worse if you've been avoiding the issue. Do not believe these myths. They can cost you everything. If you want real permanent protection, there is only one answer: become a U.S. citizen. Naturalization is the process of applying for citizenship. Once you are approved and you take the oath of allegiance, you become a U.S. citizen with full constitutional rights. You cannot be deported. You can vote. You can petition for family members. You can travel freely without worrying about abandonment of residency. To qualify for naturalization, you generally need to have been a green card holder for at least 5 years or 3 years if you are married to a U.S. citizen. You must have continuous residence, good moral character, and pass an English and civics test. But here's the important part. Even if you have some issues in your past, it may still be possible to naturalize. An experienced immigration attorney can help you determine whether you qualify and how to address any potential problems. Do not wait. The sooner you apply for citizenship, the sooner you protect yourself. Let me be very clear about something. Not every green card holder is going to be deported. The vast majority of permanent residents will continue living their lives without any issues. But the rules have changed, the enforcement has intensified, and the risks are real. If you are someone who falls into one of the categories I mentioned, if you have a criminal record, if you've spent significant time outside the US, if there are questions about how you got your green card, you need to take this seriously. Ignorance of the law is not a defense. Hoping the problem will go away is not a strategy. Waiting until you're in removal proceedings is too late. The U.S. immigration system is complex and it is unforgiving. One mistake can have permanent consequences. But if you act now, if you get informed, if you consult with professionals, if you take the necessary steps to protect yourself, you can reduce your risk significantly. This is not the time to panic, but it is the time to pay attention. Share this video with anyone you know who has a green card. Make sure your family members, your friends, your community are aware of what's happening in 2026. If this video helped you understand the immigration changes happening right now, please hit that like button. It helps more people see this critical information. Subscribe to this channel because I will be covering every major immigration update in 2026, whether it's policy changes, court rulings, enforcement trends, or practical advice for immigrants. I'll break it down for you in clear, simple English. Drop a comment below and let me know. Are you concerned about these changes? Do you have questions about your own situation? I read every comment and your feedback helps me create the content you need. And most importantly, stay informed, stay prepared, and stay safe. I'll see you in the next video.